I'm Prophet Ron Dwayne Whitfield. I'm creating this video, as it says up here, for protection against being returned to prison and of being murdered. This document is from the Texas Department of Criminal Justice Institutional Division. I've had this document since 2012. I also thought I had thrown these documents away. There are a number of other documents that I had in this stack of file, but I didn't know that this particular document was also inclusive. So at this point, for purpose of demonstrating who I really am, I'd like to read it as a means of protecting myself from being either murdered or returned to prison for the remainder of life. Whitfield Ronald, 623-668. Identifying data. Name, Whitfield Ronald. TDCJ number 623-668. Race, African American, Black American. Date of birth, May 24, 1966. Age 31. Gender, male. Education, 10th grade. Date receipt in TDCJ for current offense, burglary of a building with intent to commit theft, was, as I've always stated, Friday, October 2, 1992. Montford Crisis Management Transfer date, March 16, 1998. Montford admission date, March 24, 1998. Prior number of prior crisis management transfer to Montford, 1. Number of prior admissions to Montford, 1. Date of report, May 15, 1998. Evaluator, Robert Saari, BA. Reason for referral. Offender Whitfield arrived at the Montford unit for crisis management evaluation from the RED unit on March 16, 1998, denying knowledge of the reason for transfer. He was admitted into the acute care program at the Montford unit on March 24, 1998, for inpatient psychiatric treatment. Offender Whitfield, voice understanding, that the purpose of this evaluation is to assess his current psychological functioning and mental status in order to make recommendations for treatment to be assessed, or rather provided, in a clinical setting. Diagnosis, treatment, recommendation, and inferences contained in this report are for this mental status. Okay, I'm losing my concentration here. So let me get a better grip on the phone and take it from this angle and go. Diagnosis, treatment, recommendation, and inferences contained in this report are for this intent only. Thus, use other than for these purposes may require reevaluation to determine psychological function. To determine psychological function. To determine psychological function. All right. Mental status and treatment needs. He gave his verbal consent for this report to be placed in his medical record. Methodology. Review of TDCJ records, review of clinical records, clinical interview, and review of recent psychometric testing, including instrument, date administered, Information gathered in preparing this report is based primarily on self-report information and has not been independently verified beyond TDCJ records, presenting problems. On February 23, 1998, offender Whitfield was transferred to the J. Montfort after staff observed evidence of paranoia and delusional thinking. When the decision was made to transfer to John Montfort, offender Whitfield refused, necessitating a major use of force. On February 26, 1998, he was discharged from John Montfort against medical advice after refusing treatment, and he was sent back to the Allred unit. On March 16, 1998, he was transferred back to John Montfort, and since his arrival, he has consistently refused treatment and refused to eat. Forced medication has been necessary. This is page 1 of 5 of the psychological evaluation. And as we made clear at the outset, it is a report of date May 15, 1998. Page 2. Until recently, there has been no evidence that offender Whitfield has received psychiatric services since 1992. However, he has had significant trouble conforming to his imprisonment. He has had a total of 67 assessments. Then, in February 1998, staff at the Allred unit observed paranoia and delusional thinking, and after refusing treatment at Allred, he was transferred to John Montfort, a transfer that necessitated a major use of force. Denying the need for psychiatric services, offender Whitfield refused admission and was discharged against medical advice. Offender Whitfield was transferred back to John Montfort about 3 weeks later due to persistent symptoms. Although this time he was admitted voluntarily to John Montfort, he has continually refused treatment and has been on a, quote, hunger strike, unquote, protesting both his, quote, illegal, unquote, imprisonment and the recent major use of force. He has been force medicated, demonstrating no resistance on a number of occasions. So on a number of occasions, he has resisted, demonstrating no resistance. Okay. On a number of occasions. After which he has become willing to eat. Frequently, he writes long letters, involved letters. He writes long and involved letters to TDCJ staff protesting his imprisonment and the forced medication. Additionally, I'm trying to get comfortable with this phone. Okay, additionally, he wrote 2, quote, love letters, unquote, to a nurse, one of which included an attempt to solicit $100. Offender Whitfield's rationale for these letters was that he was medicated, which impaired his judgment. At the time of the interview, he was continuing to refuse pharmacological treatment and was persistent with his hunger strike background. Please refer to the social history prepared during this admission for a complete description of offender Whitfield's developmental history of aggressive behavior. Offender Whitfield has a history of aggressive behavior in both the free world and while incarcerated. As a juvenile, he was charged with assaulting another male and was released to parole. He has also been charged with resisting arrest while incarcerated. Offender Whitfield has received 8 formal assessments for threatening staff. However, he has received only 1 assessment for assaulting staff. Additionally, he has received 2 assessments for sexual misconduct. By that they mean masturbating in the presence of female officers. Just for those of you who would be wondering what they mean or what is meant by sexual misconduct. Not that I engaged in any improper and immoral behavior. I don't do that. Didn't do that. Now, back to where I was. I'm against that. Since his reception into TDCJ in October of 1992, he has received a total of 67 assessments, which indicates extreme difficulty maintaining appropriate behavioral controls. His history of aggressive behavior indicates that although he is likely to be verbally aggressive, he is significantly less likely to be physically aggressive. History of suicidal or parasuicidal behavior. Parasuicidal behavior. Offender Whitfield denies a history of suicidal or parasuicidal behavior. Psychiatric history. Offender Whitfield was received into TDCJ on October 2nd, 1992, Friday, for his current offense, burglar of a building with intent to commit theft. Shortly after this reception, he received a psychiatric interview after reporting to a social worker that he was, quote, Martin Luther King, unquote, and he identified himself as Andrew Johnson, the 17th President of the United States, in written communication to the warden. The evaluating psychiatrist noted that Offender Whitfield is a, quote, very intellectualizing person, unquote, with some abnormal thought content and thought processes, both of which are marked by significant grandiosity. For example, the psychiatrist noted that Offender Whitfield evidenced tangential thinking when he jumped from talking about an alleged conversation with Elvis Presley to an unrelated topic, which was, quote, going back and forth to Apple Tree Grocery, unquote. The psychiatrist confronted Whitfield with his claim to be Martin Luther King and Andrew Johnson. Offender Whitfield apparently denied this, though the psychiatrist reports that he observed written material that Offender Whitfield had signed, quote, Martin Luther King, unquote, explaining that his relationship, or rather relation, to Martin Luther King is based on shared concept and that he shares similarities with Andrew Johnson, in that as Andrew Johnson was impeached from the presidency, he offended Whitfield by virtue of his page 3 of 5. Page 3 of 5 is focused. Okay. Imprisonment has been impeached from society. During this interview, offender Whitfield also evidenced grandiosity when he explained to the psychiatrist that God has special tasks designed for him. And his incarceration is part of this plan. He then went on to explain that if he had the funds, he might build a prison system, quote, as large or larger than that of Texas, unquote, with, quote, rehabilitation, unquote, as the demonstrated goal. At this time, offender Whitfield denied the need for psychiatric treatment, and the psychiatrist noted that though he suspected that offender Whitfield, quote, has a serious mental disorder, unquote, he was unclear about the most appropriate diagnosis. Although he has functioned since 1992 without psychiatric treatment, he was recently observed evidencing paranoia and delusional thinking at the Allred unit, and transfer to John Montfort was deemed necessary. See presenting problems for more detailed information. Substance abuse. Offender Whitfield reports a history of cocaine use and marijuana use. He has been diagnosed with axis disorders of 304.30, cocaine dependency in a controlled environment, and of 305.20, cannabis abuse in a controlled environment. So they refer to the community in which I live as a controlled environment. Nice to know. He has been arrested for soliciting drugs, and in 1991, he received outpatient substance abuse treatment at Choices Riverside Clinic, Houston, Texas. Medical history. Please refer to offender Whitfield's medical records for information regarding his mental status and behavioral observations. Offender Whitfield is a 31-year-old African American. I thought I was a Black American born in the United States, who presents for interview in standard correctional attire. He appeared to be younger than his stated age of 31 years. He related to the examiner in a fairly cooperative but grandiose manner. He made poor eye contact and appeared to perceive the evaluation as unimportant, an attitude that is consistent with his belief that he is not psychiatrically disturbed and does not need treatment. In answering questions, he appeared to give his word choice considerable deliberation and to pride himself on his intellect. His mood appeared slightly depressed and his affect was well contained. He reports that his sleep is adequate. Although he explained an appetite, or rather although he experiences an appetite, he is not currently eating since he is on a, quote, hunger strike, unquote, protesting his imprisonment and the major use of force that was used on him, or his first transfer to John Montfort. Offender Whitfield was oriented to place, or rather person, place, time, and situation. His memory, concentration, and attention all appear to be intact. His intellectual functioning appears to be above average based on his vocabulary. Fund of knowledge, writing skills, and complexity of concept. His thought processes were coherent, logical, and goal-directed. He denied hallucinations and suicidal ideation. He did not evidence delusions during the interview. Offender Whitfield does not believe he needs psychiatric treatment, and when he was asked if there was anything wrong with him, he replied, quote, no, unquote, evidencing no insight into his disorder, psychometrics. Offender Whitfield was on assault precautions at the time of interview and therefore was handcuffed, which prevented him from completing the entire MMSE. However, based on the portion of the test that was completed, he evidenced no deficits. The result from the SCI-SR-CV identified the following risk factors for suicide. Offender Whitfield evidenced 10 long-term risk factors of a possible 24. These risk factors include demographic variables: 31-year-old, African American, male, none. This is page 3 of 5, and yet again this is another page 3 of 5, so it doesn't go here. Now we're at page 4 of 5. Married, serious psychiatric disorder, psychotic disorder, NOS. History of chronic cell restriction, perceived treatment failure, history of impulsivity, lack of social support, chronic perturbation, and a long sentence, 35 years. He also evidenced 7 acute risk factors of a possible 21. These include a recent discharge from an inpatient psychiatric facility, John Montfort, February 26, 1998. Recent major use of force, February 23, 98. Recent relationship turmoil, pen pal. Recent abandonment by someone important, pen pal. Significant anniversary approaching, birthday, May 24, 1966. Greatly increased perturbation and recent cell restriction. Summary of findings. In the clinical interview, offender Whitfield reported that he often feels sad and hopeless. However, he did not evidence other symptoms of depression. He denied both suicidal ideation and homicidal ideation. He also denied hallucinations. His thought processes and thought contents were both appropriate. There was no evidence of there was evidence of antisocial personality traits, especially in terms of grandiosity. Although his medical records indicate the presence of delusional and paranoia, these symptoms were not present in the clinical interview. Offender Whitfield did appear to be grandiose, and his belief that he can get results from protesting his incarceration through a hunger strike is not well grounded in reality. The information in his medical records was somewhat ambiguous concerning whether his beliefs are, in fact, delusional. When confronted with, for instance, the possibility that he believed he was a famous person, he did not state that he was this person. Or does it really mean he did not state that his was this person? Rather, he drew parallels between himself and these figures. Although this indicates grandiosity, it is unclear whether delusions of grandeur are present. Therefore, one possibility is the presence of a psychotic disorder characterized by grandiose delusions. Another possibility is that his symptoms can be explained through an antisocial personality organization. Offender Whitfield appears to have the antisocial characteristics of trying to command status through asserting his nonconformity. For example, he recently said that he does what he has to do and, quote, they do what they have to do, unquote. The recent hunger strike and treatment refusal are likely to be related behaviors, since he readily commands attention and asserts his independence through these refusal behaviors. Highlighting the antisocial tendency to resist authority is a comment made during the psychiatric interview in 1992 that he would not call officers, quote, sir, unquote, since they had not earned his respect. Moreover, he consistently writes letters protesting his imprisonment and claiming that his rights have been violated, a behavior which may reflect an antisocial desire for autonomy. Illustrating an antisocial manipulativeness, Offender Whitfield said that he would consider accepting psychiatric treatment if he were transferred to Skyview, a unit much closer to his home. Therefore, under his behavioral problems, example given, 67 assessments may be a need to assert himself as an important powerful person who is not to be pushed around. This need may sometimes become excessive, resulting in delusions that he is actually a famous person or related to a famous person. This extreme grandiosity may become manifest in times of extreme stress and feelings of helplessness. For instance, when he was first received into TDCJ, the interpersonal strategy of the antisocial is often guided by a belief that others intend to exploit or hurt. To protect against such exploitation, the antisocial must arrogate power in some form to guard against this exploitation. Therefore, offender Whitfield's behavior is likely to be guided by a passive acquisition of power through refusal behaviors that demand others' attention and allow him to feel some sense of control in a situation in which he feels powerless and vulnerable. Given the limited time available for psychological intervening, it is difficult to determine whether his symptoms are better explained by a psychotic disorder or an antisocial personality organization. It is probable that his symptoms are explained by a combination of both. 4 or 5. Yeah, just my luck, page 5 would be out of place. So I will briefly look for it if I find it. Fine. If I do not find 4 or 5, well, it could be almost anywhere. So, oh well.
You have reached the Federal Bureau of Investigation. If you are calling to report a bank robbery, please press 1. Para español, por favor. You have reached the Federal Bureau of Investigation. If you are calling to report a bank robbery, please press 1. Para español, por favor, oprima el 6. If you are calling to provide information regarding a potential crime, press 2. If you are calling with questions concerning employment with the FBI, please visit our website, www.fbijobs.gov. If you know your party's extension, please dial it now. Please note, the FBI Houston Division is located at 1 Justice Park Drive, Houston, Texas, 77092. Our normal business hours are 8:15 a.m. to 5 p.m. Monday through Friday. We are closed on all federal holidays. If you wish to speak to an operator, press 3 or stay on the line. FBI Houston.
Hi, always good to hear your voice. Now, I need to speak with Special Agent Ryan Collins, please.
What was the name?
Ryan Collins?
Collins, you said?
Yeah.
And what was the last name?
The last name is Collins. I think the first name is Ryan. I might be off on the first name.
Ron Collins in the building, sir.
Ma'am?
No, Ron.
No, I didn't say Ron. I thought I said, I'm saying Brian, B-R-I-A-N. But his last name is Collins. I do think I remember that correctly. Last name is Collins. Whoever the special agent was on duty yesterday, whoever he was.
Oh, you were here yesterday?
Yes, ma'am.
Okay, hold on just a moment.
All right.
What time were you in the office, sir?
They have my ID and take photos of that, but your question is what time? I'm not sure what time I got there. I mean, it could have been between 12 or 2, 1.
Was it morning or in the afternoon?
It was in the afternoon.
Okay, just a moment.
Okay.
Mr. Brian?
Hey, Mr. Brian, this is Ron Whitfield. This is spoke with you in an official investigation on yesterday. You remember me?
I do.
Mr. I don't want to start off like the doctor did yesterday after you identified who you were, but for this pro-hop advice, I might need to do that. Sir, do you remember the gist of the conversation you had with the doctor and what you told me before I left your office on yesterday, being May 9th of 2007?
Do I remember?
Yes, what the doctor told you about our limit to this.
Yes, I remember.
Can you recite what he told you about the authority for holding my wife, Brandy Charles?
He said that there's a court order,
Mm-hmm.
and you can go to probate on McGregor Street to get the order.
Sir,
And that your wife also has.
I have a constable here right now, FBI agent. Which school are you, constable? Just don't trespass. Why are you here? Why you look? Okay, I have an FBI on phone right now. Brandon Charles has been involuntarily committed at a hospital. We had a Dr. Lobster, FBI agent, conducting an official investigation. As you remember, Mr. Coleman told Cummings a lie. He's trying to lie to us.
Hey, this has nothing to do with him.
Okay, this nothing to do with you. Now, how can I help you? Just excuse me, Mr. Brian. It has nothing to do with you.
It has nothing to do with Comey.
Oh, okay. They say she's in Behavioral Memorial Hospital.
No.
And they, Thank you, sir.
Behavioral Hospital of Bel Air.
I'm sorry, I gave you wrong information. It's Behavioral Hospital of Bel Air. Yo, could you tell me why you looking for her? I can take those. I'm her husband. What for a court date for what? They know they got her been held against the will. They already know what she is. Okay. She's not been sued, just me. Okay, sir, I wouldn't even, oh, thank you, sir. Thank you. Okay, well, sir, Mr. Collins, they don't have an order for holding Brandy. She's not.
Did you go to probate?
Yes, yesterday and today. They told me yesterday that they don't have an order, and they said they would try to get one today. And I went there this morning to be at the hearing. No such hearing, none of that. None of that.
Well, I don't know anything about a hearing.
No, that's what they told me. No, that's what they told me yesterday. You see, I'm sorry. I should have stated that they, when I called CPS back and talked to, the administrator, she said that, after I told them there's no order, well, we'll try to get one today. In fact, she'll go to court today. But she he's already told the FBI agent that, she's been held, and that, the address, that wasn't a good address, but she's been held pursuant to an order. That's why I was asking you these questions, just to make sure that,
Right.
So, no, she's not being held pursuant to any order. I've instructed her, not advised, but instructed her to not take any more of their dope and to not do any more talking to their doctor. You have your own doctor. You have your own medication. I've left message with her doctor as a violation patient and doctor relationship. And do that. So now having put you on, no, he lied to you. They have no legal authority for holding her. And they also told me, and it's recorded, that a constable, first she told me, if I'm not mistaken, that a constable from Montgomery County transported her to that hospital. Then the day she said, I didn't tell you that. I told you that he signed the order or something to commit her. I didn't know constable could sign commitment orders. But they, it's just so many lies now. They can't get their stories straight anymore. But what we do know, they don't have no. What he told you yesterday was a lie. So maybe that's why he was defending himself when you had to tell him that you would just shut up and quit defending yourself. Maybe I can ask a question. We can be done with it. So I'm gonna go ahead and come back over and do if I need to, so we can reopen this investigation. Get my way.
I don't have an investigation open.
You just called him yesterday, and he lied to you about having my wife. They have authority to hold my wife. He just
What I would suggest you do is go back to probate.
I just went to probate. No, sir.
No, I understand.
No. They're not. Respectfully, because you record and I record. I am officially moving for an investigation. He just lied to you. They sent me state action. They sent me to Mexico. They sent my wife to China, and my child stayed here in the United States. State action all in one day. Separated the whole family. And now you got a doctor lying to an official in his on his duty, conducting an investigation, calling you, asking you about what legal authority, because you record the conversation too. What legal authority, doctor? All I want to know, what legal authority have you got to hold this man's wife? And he told you he had an order in place. There's no order. Therefore, her detention is illegal. That's what they told the city Houston, let that man go. And they did. They took me over to the sheriff. The sheriff told me, no, I know I'm going off on the other end. But even the city of Houston violated the court order. When she told me to release me, instead of releasing me, they sent me over to another agency. And that agent had no sense that he ain't coming in here. The judge now already told y'all to release him. They told you, or he told you, we're holding this woman pursuant to a court order. There is no order. Therefore, God give us a right to be secure in our freedom, our liberty. You cannot strip me from that without due process. And the process requires you have a court order. You don't have it. Then you must release me, and you have committed a violation of Title 18 USC Section 242. This is state action. It's not private people acting. This is state action under color of law. Therefore, state action, do they have brains? Everything that they doing, they claim they have state authority for doing it. And there's no such authority at all. You can't do, like even Mr. Coleman put it, it's a man's right here. Intent. The element under Title 18 that has to be established is willfulness. You willfully. You know what you're doing. You lied to an FBI agent asking you, man, all I want to know, what legal authority have you for holding Granny? His response was he's holding her pursuant to a court order, and I can go to the probate court and see that no such order exists. I'll move for an investigation. I'll be calling Ted Cruz, all my senators now. I'll be doing whatever I got to legally do. So after getting this official, I want my wife to follow it. I've instructed you don't do no more talking to them. Don't take no drugs, and they'll probably give you some drugs. You ain't gonna ever know who you are no more. Now it's all about going to be about covering it up now. Covering up everything. Trying to cover it up. So, do I need to call Washington, or are you going to go open this investigation and get my wife?
No. Here's what I need you to do. I'm assuming there are police at the probate office. I need you to go back there, ask them.
You want me to become the FBI investigator?
No. I don't.
Well, sir, I'm not. See, they might try to lie. They might try to lie.
Listen to me, then
I will listen. I will listen, but I have to be careful now because they might try to say I did this, but they don't want you having your phone. So I don't want to have no protection if I go there. Well, they gonna take my phone from me. Say, everywhere I go, I gotta have my phone because these people lie too much to me. They might start saying I was acting excited. I told them unless you can show me a law where I can't. I told the sheriff yesterday and all of them, I don't want to calm down. I want to get excited. And they stepped back and like, well, I ain't never heard them before. Everywhere I go, they want you to calm down. That's just what it is. The American people of the United States has been too damn calm while the government has been fucking over us. I don't like that. Trying to take our freedom of speech. Fine, they took it. So if I go there, they're going to lie. Say, what you over here doing? He was doing this and shit. No. I just made clear to you, clearly and vocally, that there's no judicial office. Now, I'll say that on the first, because it's like Mr. Combs did say, it's a crime to lie to you. They have no law, so they act on the color law. That's an element. They need me to go on. Oh, well, I'm not going. Now I'm going to get all the way calm now. Ain't no need to get excited because they do hung themselves. Again, my wife went to China. I went to Mexico and Caden stayed right here in the U.S., whatever his name is, United States, whatever his name is, and they got Caden. It seems like this is all about Caden. It's a crime. They told me it's a child abuse to claim Donald Trump. It's child abuse to what else? Everything I got the law, child abuse. None of these allegations has anything to do with child abuse. No. And the judge already signed an order. There was no proper cause. You know that man house. There was no proper cause. There was no exceedance. The judge just has to take his time. Get him out of his audit release. Rather than release him, they send me over. Come on, nah, you not. Surely you've been trying, haven't you?
Yes, I have.
Okay, so you seem like you kind of feel God a little bit. I've made it clear. Now, like I say, I can't go over them. I'm going to sit back and stop their way now. I done did my footwork. I got them all recorded. I also got everything at the hospital recorded. Everything they said had to be escorted out the hospital. I was yelling and screaming, but the video, so that's why I put it all over the world. See, look on Facebook. See, but look at what he's saying in the petition, but look what the proof shows. Excuse me, ma'am. Why are you holding my wife? We can't. Okay, fine. Brandon, are you suicidal? Do you have any plans to kill yourself anyway? No. Okay. You can't be recorded. Is this a public facility? Yeah. Oh, okay. Then I can record. But if you don't want to record, I'll turn this off. I'll turn it off, and I'll go outside and turn it back on. Out of that portion of it, now I guess I'm in the lobby. I guess maybe I can record out here. And everything that they said shows to be lies. And they got their own cameras. They must have forgot. Because if I went in there and started doing committing crimes, they'd use the same recordings to have at my trial. So we're going to use these same recordings that they got and the ones on my phone to show everything they said. So they don't tell us who said this. Nobody's accepting accountability for perjury. Nobody is being identified. But I made clear on the recorded line that CPS is alleged. It is alleged. It is by who? John Washington, John Adams, Thomas Jefferson, James Madison, James Monroe, John Quincy Adams, Andrew Jackson, Martin Van Buren. Which person they alleging this to take my child? All we know is just that it's alleged. But so good, we got technology today that we got videos to show that's a lie. But now, before letting you go, sir, I can't go back to probate because they're going to take my phone. And once I'm in there, I won't be I can't take that chance. Because the state now got to try to figure out what we can do because he got us for purge. We got one civil judge, and she committed a crime because you cannot proceed in a judicial proceeding, in any judicial proceeding, taking people's children without first. See how they was coming out here to serve Brandy? They never served me. You cannot proceed and say, I appeal. You can't do that because the court has to have what we call jurisdiction, power. A judge don't have jurisdiction. She or he gets only judicial authority, but that authority comes from the power that the court must have. There is no subject. The court has subject matter, but you also have to have jurisdiction on my person. You have jurisdiction on my person, you get cussed out. You will get cussed out. Because you don't have no jurisdiction on my person. It must be both. And they know this. And finally, before you can proceed, even if there had been jurisdiction over the subject matter and the party, you still cannot proceed until the parties appear. You have to, by process, serve me with notice, summons, citation appear. You have, in this felon form, I have a right to, like it said, you have a right to hire an attorney. This proceedings over here, I have to be there. Brady has to be there. We have to get notice of what's in it, what the state is going to do, what the state is going to do. So you can't just do this here, don't worry about that. Forget all. No. I'm protected from that type of action. And if you're willing to do, you commit a crime. I didn't say this. The Supreme Court's opinion tell us this. No, Mr. Collins. I like to talk a lot when they violate law. So there'll be no misunderstanding, no room for it. No room for creating confusion where there is none. Pursuant to Title 28, United States Code Section 1746, subsection 1, not subsection 2, which applies to the United States, not statements made from another country or somewhere. I, Ron Dwayne Whitfield, a person of sound mind, competent, and able to make these, to make the foregoing statements as their materiality, say that they are true, correct, and not misleading. On a recorded line to Special Investigator Mr. Brian Collins. Further said not. Okay, that affidavit has just been that's been terminated. Now I can just talk loosely. Mr. Collins, I need my wife removed from that place. They have no judicial authority to hold it. No legal authority, I should say. What will FBI do? Because I need to now get on the phone, talk to the House, the chairman, on the judicial conduct, because the federal government, when states are acting sort to the federal constitution, then, Congress has to step in and see what the hell is going on here. When you act pursuant to, you claim legal authority, act pursuant to the 10th Amendment. The 10th Amendment gives states power. All the other power is reserved to the people, respectively. The 9th Amendment tells me that the rights that God gave me, 7 rights that God gave me, not listed, that already listed that the Constitution recognized, shall not be denied. So whatever them unnamed rights are, don't waive them either. I know that my wife has a right to be free and secure in her liberty and in her property and the life that God gave her. And I respectfully submit that the process for depriving her of that protection has been violated. And I respectfully submit that former and the late Chief Justice Marshall, in an opinion landmark in the 1800s, where before President James Madison was president, he was secretary, I believe, when he was sued, he sued someone. I'm just so excited. Where the Chief Justice made clear that if I claim an injury, my government must provide me a remedy. And the actions of a president, of people under president, like Social Security, are the actions of that president. That's his act. They act for him. And so, I always state that they acting on the color of law. They acting willfully. And I do know my child is in the United States. I do know that my wife is, they removed her and all this, all pursuant to state action. Yet she denies everything. And the video shows they did nothing but lie. So, now, having said all that, what are you doing about it? I made the complaint. I made my official complaint.
Yeah.
I stated the fact.
The order from your wife?
They don't have an order.
Did you talk to your wife about that?
She said they never gave her an order. She never had seen any attorney nor a judge. In fact, the woman I talked to yesterday, identified as Miss Katie, you probably recorded, says that she would be taken to the judge today. But he already told you she was already committed. He lied. That's what this is about now. He didn't lie to you while you were conducting the investigation. You had told him who you were. You told him why I was there, and you told him what the nature of your call.
I was not conducting an investigation.
You have to be. You can't be doing it.
I was calling someone on your behalf.
Okay, even so. Well, still, he lied to you.
That doesn't make it a crime, unfortunately.
But Ms. Cummins did say it do, because FBI and just don't pick up phones and just start.
So you're telling me you know my rules better than I do?
No, sir. I'm not saying it. I'm not here to, wait a minute. Let me say this right quickly. I'm not here to create a friction when I need the government to do its job. You were told yesterday while on duty, making a call to a doctor while you were acting as an FBI agent, that in the course of the performance of your duty about the whereabouts of my wife and what authority have they, and you were told she was being pursuant to an order. That was a lie.
Let me ask you this. When you went to probate yesterday, did you actually get inside and pull the records? Or did you refuse to go inside because they wanted your phone?
That was a specific question. I specifically went inside, gave him my phone, and the white, rather Caucasian, I would say, receptionist said that the probate court was closed and that there's no way I can review any records because they are closed to come back tomorrow. I came back, which is today, and they told me that also, let me be clear here because it'll be confusion, the hospital also told me that we're going to get it done today. We'll try to get an order today. And she's not on no docket today. They're not trying to commit nobody today, and there's no records to me.
Okay, but finish. Did you go today and try to find the records?
Yes, that's what I said today. Yesterday, sorry.
And what did probate say?
They wouldn't let me go into probate. They told me to call, so I called, and they had a constable to answer the phone, and the constable said that somehow the clerk wasn't there, and that my wife was not on any, no, let me not wait, be careful here. I think, I'm not so sure they got the record. I think he told me that, the people outside told me that she's not on the docket. They called the court.
Yeah, but I'm not talking about a docket. I'm not talking about a court case. I'm talking about the warrant for her to be in that hospital. That's a record. You shouldn't have it.
They say they don't have that. That's what I've been telling you. They don't have that.
Who said that?
Okay, when you go into the building, these people that's at the desk, they call, because they got to go in the computer, and they don't have any information about my wife whatsoever. So I called, so they told me to come back tomorrow, which is today. I came today, they don't have, and that's why I told you, she's not on the docket. There's nothing about my wife there. She's not going to be, see, them people at the hospital.
Well, here's the problem then. Here's the thing. When you call and you talk to a constable, and he said there's no record there, why didn't you tell the constable, okay, then I need some help over at the hospital?
Why did I not tell the constable that, okay, he is assigned, I guess, to that court?
Yeah, but he can make a phone call. He can get somebody else to help.
Well, I already have informed an FBI investigator by the name of... Well, I understand what you said, but I'm answering your question. You might disagree.
But that's the wrong answer.
Well, he did tell you that they already had a court order. I also told you on yesterday that I've called 911 several times. They even called me back.
They had a court order.
Who? Who?
The constable.
He don't know. He said that he said that I asked for, he's the constable, I asked to speak to the clerk. He said the clerk, if I'm not mistaken, was not there. And I'm not sure what I said after that. I think I asked him about my wife. Don't hold me to that. Because they'd already told me at the desk, they told me the people at the desk told me she's not on the court now, but you can go over there and call the court, but you can't go in there, but you can call. When I call, instead of getting a clerk, I got a constable. I asked the constable to speak to the clerk. His response was, don't call me on nothing, that she's not there. And from there, I got so, excited. I said, well, it was enough for me, suffice it to say, that they told me they were going to do this today. So yet again, there's nothing going down. I said, I got time for all that. They told me this was going to happen today. I come down. They don't know what the hell I'm talking about. That I do know. They don't know what the hell I'm talking about. We ain't got no Brandon Charles in our docket. Ain't nobody going to see no Brandon Charles. And you want to, you can call the court, so you ain't going to go in there. You can call the clerk and whatever, but you ain't going in there, so just call the clerk. I call the clerk. He comes in. She ain't here to this. So, okay, all right. Okay, bye. All I'm telling them about. Oh, okay, fine. Y'all ripping and running me, everywhere I go, it's a lot. So
my recommendation is to go back physically to the probate court.
No, they're going to arrest me. I can't do that. Because they will lie. Texas right now has to cover up with all these lies.
If you're not going to do that, then there's nothing I can do to help.
You want me to go back to the probate court, and whatever you want me to do, why don't you just pick up the phone and do it?
Because I have no jurisdiction to do it.
The law is not about you. The law provides the FBI.
We've gone over this.
So I'm telling you, sir, this is what I'm telling you on a recorded line. If I were to go back to the probate court after they already told me you are not going in there, you can call. I'll call the clerk.
I don't want you to go into the court. Not
they
the court itself.
Yes, but they gave me a number, and I called that number, and the constable already told me that the clerk was not there, and...
Well, that can't be gone forever.
Okay, all I can do when I call back, the clerk... okay. My wife has told me that they've already told her that she's going to be there tomorrow anyway. She's going tomorrow. So it's really nothing the constable or the clerk can tell me other than her hearing a step for tomorrow. That's not my purpose for being there. My purpose for being there is to get that order that he told you they already have for holding her. Not what order that they might obtain tomorrow. This is your authority for holding her right now. Against her will. That's what this is about. Not what they might get tomorrow to justify it. You need judicial authority for holding my wife right now.
I understand.
Okay, they didn't committed a crime. He didn't lie to you while conducting it. You can call it what you want to. Congress don't say because you was on duty. You
have access to your wife, right?
I don't have no access to my wife other than on the phone.
Okay. Tell her to call the clerk.
What the clerk gonna do? She already been told that she will appear before a judge tomorrow.
No. You just pointed out that there needs to be a warrant effective now.
A warrant? Uh-huh.
Have her call the clerk now.
Mm-hmm.
Today.
Okay.
Before tomorrow.
Uh-huh.
And obtain maybe they're not giving it to you because they can't.
They say they don't have it, sir. Am I not being fair to you?
I understand that.
They admit on a recorded line. I got the recording that there is. There's no warrant at all. There's no artist, no judge. That's not unclear. They want to go get one tomorrow. We'll try to get it tomorrow. We'll see if we can get one of our own judges to say she's crazy tomorrow, so we can justify for having her.
I understand. I understand what you're saying. Your wife called the clerk.
My wife ain't got no business calling nobody. I told my wife, you don't do no more talking. I'm telling you, sir, they have no authority for holding her right now. That's what I'm telling the FBI right now. No authority for holding my wife right now. God gave her the right to be free unless she has committed a crime, unless she is crazy. And you got to get a goddamn order from a magistrate to hold that woman against her will. That's the goddamn law of the United States. They don't have that. And I'm not going to give you, what you might get done tomorrow, it's going to be tomorrow. Everybody might be dead tomorrow. I'm talking about today. They have no legal authority for holding her today. That is kidnapping. What this is the United States Special Agent Collins? This is you goddamn United States. We don't play that in our country. I want my wife removed from that goddamn hospital. I want criminal charges filed against that hospital. Whoever got it. Asking pursuant to current state law, I say, every motherfucking time you tell them my wife's been held against her will, and they were on time to goddamn try to get one of their own judges to say she's crazy. When my wife is steady telling y'all she don't know why she's denying all these allegations. It's all about shielding my baby, man.
Why won't you ask your wife to call the court?
Yeah, okay, then special agent in charge of what's his name say call it prayer. She gonna say what?
Ask for the warrant.
They don't have a warrant, I'm telling you.
That's what they told you. Have her ask.
Miss Agent, Kyle, I'm gonna do just as you advise. Thank you. Goodbye.
Thank you.
You have reached the Federal Bureau of Investigation. If you are calling to report a bank robbery, please press 1. Para español, por favor. You have reached the Federal Bureau of Investigation. If you are calling to report a bank robbery, please press 1. Para español, por favor, oprima el 6. If you are calling to provide information, Harris County Police Department, how can I help you?
Just a minute, please. What's right? What's General? Ma'am, my name is Ronald Whitfield, and is this Miss Jennifer?
I'm sorry, what was that?
Are you Miss Jennifer?
No.
Okay,
Are you trying to reach Jennifer?
well, it doesn't probably matter. You probably, if she's not there. My purpose of calling is to call like on May 8th, I believe, Monday of this month, and I'm calling back. My wife is, she's in, I don't know how to say this. What I'm getting at, I would like to give you her name and address. Date of birth, and can you tell me how many commitments, what they call order of protected custody, have been rendered for her involuntary commitment?
I'm sorry, I honestly did not understand what you were trying to ask for.
Okay, I called in the past. I want to know how many orders for her involuntary commitment have been entered in the system.
Okay, hold on. Give me a moment.
Okay.
Give me 1 moment, okay?
Sure.
Hi, Office Mariana speaking.
This is who?
Mariana.
Miss Mariana. Hold on. What's wrong, baby? No, tell her to call you back. Okay, ma'am. I'm asking. For how many involuntary commitments have you for Brandy Charles?
I'm sorry?
How many involuntary commitments? How many orders, warrants for have you got for Brandy Charles?
I think you're calling the wrong department, sir. Or this is probate. This is not probation.
No. I'm talking about for mental warrants for commitment to hospitals.
I'm not really sure what you're talking about. I mean, we don't issue warrants. That's the thing.
Ma'am, let me get a little when a person has been found, you can file an application for a person to be involuntarily committed civilly for suffering from known issues, not suffering from known illness, and you get this by filing an application with the Harris County Psychiatric Center. It's not just the clerk, office of the probate court.
Mm-hmm.
Huh?
Okay, so, well, okay. What exactly is it you're looking for, sir?
That's what I'm asking. I'm asking how many orders for protective custody for Brandy Charles, date of birth.
Hello?
I'm asking you how many orders for protective custody of Brandy Charles.
Do you have a case number?
That's what I'm asking for. How many protective orders have you got? When you type of her name, everything comes up.
Sir, I can't hear you.
You're saying when you type up her name,
Hello?
Can you hear me now? Yes. Hello?
Hello?
Yeah.
Hello?
I can hear you, ma'am.
Hello?
Hello.
Yes?
Yes, I was saying, when you type up her name, that information will come up.
I mean, if her name pops up, then the case number will come up.
That's what I'm saying. So I'm asking you, how many prior commitments?
What is her, sir? I don't know, because, I mean, you just said her name, but, I mean, I haven't typed anything, so I'm not sure what exactly.
Her last name is Charles, Charles.
First name?
Randy
Randy?
with a B. And the middle name is Brene, B-R-N.
None, sir.
So, yes, ma'am. No, are you telling me that no orders for protective custody and orders of transfer and commitment to hospitals come up?
No, sir.
The date of birth is January 1st.
We don't go based on date of birth, sir. We need the name. If the name doesn't come up, then we don't have nothing under her name.
Okay, the name, just one last time, ma'am. The name is B-R-A-N-D-Y. B-R-N-A-Y. Last name is Charles, C-H-A-R-L-E-S.
No, sir.
Okay, who am I speaking with, ma'am?
My name is Mariana.
How do you spell it, please?
M-A-R-I-A-N-A.
M-A-R-I-N-A. And this is the Harris County Probate Court. This is what, number 3
No, this is not the court. You're calling the probate office.
Probate office. I'm calling for I was calling for the courts. The clerk's
You're
office.
calling the wrong office.
Wait a minute, is this the clerk's office for the court?
This is the probate office. We're the department that takes all the documentation and all the paper intake. So, say if they would have filed anything on the young lady, we would have it in our system. If it's not on here, then we don't have it. We don't see one filed for her.
Okay, well, yes, ma'am. I guess that's be any more clearer than that. This is where, when a probate judge, just want to be clear, issues or renders, these are legal terms, when used in laws of art, when a probate judge orders a person to be committed to a hospital, all the paperwork is filed with the probate office, correct?
Yes.
Okay, all right, then. I guess they got the wrong Brandy Charles. Thank you.
You're welcome. Harris County Probate Department, how can I help you?
Just a minute, please. What's Brandy? Ma'am, my name is Ron Whitfield, and is this Miss Jennifer?
I'm sorry, what was that?
Are you Miss Jennifer?
No.
Okay,
Are you trying to reach Jennifer?
Well,
Okay, well, I guess that's that. I guess that is that. I think there's nothing else I need to say other than the purpose of this video is to establish that I suffer from no mental illnesses. Everything in my prison medical records regarding my mental stability is couched in my claim to those officials that I was being unlawfully held. What or not I committed a crime has nothing to do with the fact that I explained to them that I was being unlawfully held in custody. One might well ask, well, if you committed a crime and you were sent to prison, then how were you unlawfully confined? I was unlawfully confined a number of ways, but the most important, well, let me explain to you the way this. I have time to do it. Set the phone down for a second, and then everybody can get it. I will keep talking until I find this document, and it will obviously explain it better than I can, I'm sure. But as I look, or while I look for it, I wanted people to hear the very fact that as it relates to my mental stability, I was protesting my unlawful confinement. And that is why I came under the care of medical doctors, psychiatrists and psychologists and what have you. And because they understood that the reason why I was going on food and water strikes is to protest against my unlawful confinement, I guess they knew that this is not something that's mentally related. This is his way, Ronald Whitfield, of calling attention to the problem. We don't understand, I guess, why he would claim that he is unlawfully confined if he was sentenced to prison. I was stating to them that regardless of the fact that I was sentenced to prison, I was never convicted. Well, you can't be sentenced to prison if you were never convicted. I agree, but I was. And so it gets crazier and crazier and crazier for people that don't understand the law to understand what exactly I mean. So, and it's still taking me some time here to find this particular document that I'm so anxious to read from. And because when I do find it, then people can understand. But I'll just kind of, here we are. Here I go. This is what I'm looking for. Didn't know I was going to be reading this, so that's why, whatever. This is a case from our Texas Court of Criminal Appeals. The volume where this case can be found, you can go online and you can say 102 Texas Crim, page 105, Texas Criminal Appeal 1952, Ex parte W.M. McCraw. And its opinion, and I'll read it. And I'll read it. Here we are. Just Google, and it'll come up. This camera's not focused well, but there it is up at the top. Ex parte W.M. McCraw, volume 102, Texas Criminal Review, or whatever that was back then. 105, Texas Criminal Appeal, 1925. At Case, Texas. Well, it'll come up. casetext.com. Okay. This is an original habeas corpus proceeding in which relator seeks release from custody under a judgment for contempt. On the 30th day of October at about 5:00 p.m., relator, an attorney-at-law, was in open court by verbal announcement from the bench by the judge, adjudged guilty of contempt of court because of certain remarks he made in the presence and hearing of the judge of the court while in session. Understand that, people. While in session. After making the verbal announcement, the judge of the court at once prepared in writing the judgment reciting the facts constituting the contempt and the punishment. This judgment was signed by the judge in his official capacity, delivered to the clerk of the court, filed by him, the clerk, and placed in the records of the court. And on the following morning at about 10 o'clock, the judgment was transcribed by okay, this is probably a better way to do this, and I see a glare, so the camera's gonna have a shadow, the recording will, and that will be another one. But I guess that's what I got to do better. I get one page, still use the other hand, and that'll remove the shadow. All right, now at about 10 o'clock was transcribed by him upon the minute book. There's a video where I talk about a minute book, which the clerks today have no idea what that is, of the court. Upon receipt of the judgment prepared and signed, the clerk issued a commitment for the relator. All right, now, just trying to find out. Directed to the sheriff. The relator was not taken into custody. Was not taken into custody at once, but on the following morning at 8 o'clock, he surrendered himself to the sheriff and was by him, the sheriff, held in custody. At about 9 o'clock on the morning of the 31st day of October, a writ of habeas corpus was issued by the presiding judge of this court. And I'm in the process of now preparing as the last attempt before going on the food and water strike to the Supreme Court, my own application for a writ of habeas corpus. Now, back to what I was reading. Issued by the presiding judge of this court. At what time the commitment came into the hands of the sheriff is not revealed, but in his return file in this court, the page 2, statement, page 2. I'm kind of doing bad, but I'll get it together, I guess. The glare is going to continue. Got to continue to hold the phone steady. All right. It's made that the relator was held by virtue of the commitment mentioned and the judgment described. Certified copies of both the commitment and the judgment are attached to the sheriff's return, the latter showing it to be of record in the minutes of the court. Upon this hearing, the facts are not in dispute. It is not contended that the conduct of the relator did not warrant the judgment. I'm not claiming that I did not commit a crime. I did. But the sole question presented grows out of the procedure. Relator contends that his detention is illegal. Just what I've done. Just what I've done. So again, people, upon this hearing, the facts are not in dispute. It is not contended. Well, I'll get like sick. I don't want to be done with this. I have to drop this application for writ of habeas corpus. So, okay, the glare, we'll do it this way. I'm sorry for this. Didn't know. If I did, I wouldn't have done it this way. Okay. Well, it's not necessary that people see what I'm reading. Or is it? Upon this hearing, the facts are not in dispute. It is not contended that the conduct of the relator did not warrant the judgment, but the sole question presented. Amen. I don't like being going through this bull crap. Oh boy. Well, I'll just read it. Upon this hearing, the facts are not in dispute. It is not contended that the conduct of the relator did not warrant the judgment, but the sole question presented grows out of the procedure. Relator contends that his detention, like I do, is illegal because at the time he was taken into custody, at the time that I was taken into custody, the order adjudging him guilty, the document that records that what it does of contempt had not been spread upon the minutes of the court by the clerk, and that its record in the minutes after the issuance of the writ, issuance, not granting, issuance of the writ, issuance in this context means to officially send out. I've never had a writ issued, and that's a crime that the writ has never issued. The great writ of habeas corpus in the state of Texas must issue by operation of law. It's so great. The legislature made it that way, but do you think it has issued? Since the legislature said that it is prescribed by law to issue, it didn't. That's another topic. The issuance of the writ of habeas corpus did not validate the detention. The respondent contends that before the relator was taken into custody, he had been adjudged guilty of contempt in open court. Unlike this attorney, I had not been adjudged guilty of burglary of a building with intent to commit theft, which is irrelevant anyway. But even if I had been convicted of such a crime or adjudged to be guilty of that offense, and the amount of punishment fixed and a formal order of the court reduced to writing, signed by the judge in his official capacity, delivered to the clerk, and filed by him as a record of the court, that the commitment issued thereon is a valid warrant for the detention of the relator, although at the time of the issuance of the commitment and at the time the relator was taken in custody, the clerk had not copied in my case, not only not at the time that I was delivered to the Texas prison system, was there no judgment copied in the minutes of the court, and no judgment rendered in the appellate court above the trial court where I was supposedly convicted. I wasn't. Not only was no judgment rendered in the trial court, but also no judgment was rendered in the appeals court. And they don't see yet God. Y'all don't see yet God. Y'all don't see yet God. Keep trying to prolong, and you will, and you won't like it. You won't like it. In the minutes of the court, the aforesaid order, in my case, judgment, written and signed by the judge, but in my case, not filed by the clerk. In this case, the judgment was actually filed. You get it? Although a judge signed the written instrument, that instrument was never filed by the clerk. And therefore, it was never rendered. And therefore, my transfer from the county jail to the Texas prison system was a crime. It was unlawful, too. Not only was it a crime because the judgment, that which purports to be one, was not copied into the minutes, was not filed with the clerk, and copied in. So that's two legal derelictions that made my confinement unlawful. One, the written purported judgment was not filed by itself. It didn't exist. Two, even had it been filed, it wasn't copied in the minutes, and therefore there was no judgment to issue to the sheriff of Harris County to transfer me from the sheriff's custody to the director of the Texas Department of Criminal Justice Institutional Division's custody. And finally, anytime a person appeals the judgment of conviction to the higher court, no punishment may be inflicted. By the very fact that a person be punished by death and sentence pronounced and appeal taken automatically to the Texas Court of Criminal Appeals, judgment is stayed in its execution pending a mandate. And once, if a court through her judges affirm the judgment of the trial court that would validate the sentence, and the mandate is received by the clerk, the trial judge has to then determine the date that the director will carry out that judgment and sentence by ordering a warrant for execution be issued, sent out to the director. You get it? So yet, even after the mandate is sent, still the director will not punish the person by putting that person to death until that director actually receives the warrant of execution, telling him or her, the director, to put that person shall be put to death before sunset or sunrise. I have to get Carla Face Tucker's the warrant that I have that tells whether she was to be put to death before sunset or sunrise. Now, the district court by statute is given the power to punish for contempt by imprisonment not exceeding 3 days. Article 1708, Vernon's Texas Criminal Statute 1920, Article 1911, Statutes of 1925. Touching the procedure to be pursued, the statutes are silent and reference must be had to the common law and such modifications thereto as are found in the precedent available. Ex parte Green, 46 Texas Criminal Reports. I guess that's what that abbreviation stands for. These precedents are general to the point that, quote, to justify the imprisonment of a party adjudged to be in contempt, an order or warrant of commitment of some sort is necessary, unquote. Rappelli on contempt, section 129, ex parte, Bufford, 1 Cranch, 456, ruling, case law, volume 6, page 536, section 49. Concerning the form and substance of the order, the courts of various jurisdictions are not in complete accord. See note in Hoffman versus Hoffman, American English Annotated Cases 19138, page 957. Also ruling, case law, volume 6, page 537. In this state, Texas, however, it has been uniformly held that the imprisonment of one for contempt will not be tolerated on a verbal order of the court. See ex parte Kirby, 35 Texas Criminal Appeal 351. And 635 ex parte Andrews, 51 Texas Criminal Reports, ex parte Al Duretti, 83 Texas Criminal Bureau Reports. In the opinion of the writer, the practice may be regarded as settled in the state that upon an application up to this court for an original writ of habeas corpus in a contempt proceeding, the incarceration to be sustained must be supported by a written order in which the conduct of or facts upon which the contempt is founded are set forth to the end that this court may determine whether or not on the facts there was a jurisdiction to adjudge the realtor in contempt. In the various cases in which this court has held a verbal order insufficient, the declaration is made that the detention must be supported by an order entered. Quote, the entry of judgment is a ministerial act which consists in spreading upon the record. So simple. The entry of a judgment, you judges on the bench today, don't you know, is a ministerial act which consists in spreading upon the record a simple goddamn statement of the final conclusion reached by the court in the matter, thus furnishing external and incontestable proof, evidence. You ain't gonna get away with evidence. I said proof of the judgment given and designed to stand as a perpetual memorial of the court's action. Words, Phrases, Volume 3, page 2403. In Kirby's case, Supra, and in others where the declaration is found that the detention is invalid in the absence of judgment entered. This is what I've been bitching about. This is what the fuck I've been bitching about. This is what I was bitching about. The realtor was taken into custody upon a verbal order. The holding has been that custody taken under a verbal order could not, after the writ of habeas corpus was issued, be validated by a subsequent written order. And with this, we find ourselves in accord. Obviously, however, in the case in which it was held that a verbal order would not suffice, the court was not called upon to decide that the written order would not support the commitment until after it was entered upon the minutes of the court. The commitment in the present case was issued upon a judgment, issued upon a judgment, issued upon a judgment. In my case, the commitment that seems to be actually R2. Can only be one, but the record contains, well, ain't no telling how many it may contain now. These people in office today are so, anyway, lacking in, they not only lack the knowledge of the process that they are required to know. They are supposed to have training, but I've got videos to show they have no clue what they really are doing. But they somehow managed to keep this going. This is the days when people feared God and you got justice. I don't know if it was extended to other races of people such as Hispanic and Chinese or Oriental or Asians and blacks, but the cases that I find, that in the old days, according to the law now, that the laws were not always just, but as they were, you could get justice if it was meant for you. You didn't have to go through what I go through today and what others go through. I heard him finish reading it. I don't need to read all this anymore. I'll just, cause I need to shave and I'm steady, scratching. Well, I just want to clarify that the reason that I went on food and water strike in the Texas prison system was not because I suffered, and nor do I now suffer from any form of mental illness. I'm just the kind of person who, just as was stated in the psychological, or what was it term, mental health evaluation by that doctor, all the other doctors were making me look like there was something wrong with me. A lot of things that had been put in those various other reports, and even after this report, were untrue, misleading, making a bad impression of me, making people think that I'm crazy, making people in my family think that I went crazy. And now that I'm out and I'm able to explain the law, now they get it. But they didn't then. And it is my hope that the people that listens to what I say and watch what I do will get it. There is nothing mentally wrong with me. When I was in prison, I needed the prison system, those that work for the system, the wardens, the directors, everybody. Look, man, I'm not here legally. And as a result of that, I don't want to say that I was like telling them what they had to do, but inside Because I look at it this way. You know that you are unlawfully being held. Now, the people that are unlawfully holding you don't know that. All they know is that they got a piece of paper, and whether that paper is good or bad is immaterial, it's irrelevant. But as long as they have it and no one from the courts have told them or any other person in authority that they must cut you loose, they're going to hold you. Are they going to treat you in any other way than other inmates are treated? No. You're going to suffer and you're going to be punished. And I had a problem with that. I had a problem being in the Texas prison system when the record and the evidence and the proof shows that, first of all, and it's not even relevant right now, I was never even charged with a crime. As I've said before, the only person that can charge me with a crime, swear out an affidavit supported by probable cause, is the person that was injured. And this person never swore out an affidavit that I burglarized a garage. Instead, they got a name on what is called a probable cause affidavit of a person who the Miranda warnings reflect as V. Franklin. So this other separate document states that I had been in the custody of V. Franklin to be given my statutory warnings. You have the right to remain silent. The person V. Franklin is not a person whose garage I broke in. Therefore, you can understand now that since this person has, the only way you can be charged with a crime is someone accuses you of a crime. And the only person who can accuse you of a crime is someone who has knowledge that you committed a crime. Someone has to have knowledge, personal knowledge. You can't go and cause someone to be put to death, charged with murder, or any other crime just because, excuse me, yawn. I cannot just go, if I didn't witness a murder, a rape, a robbery, I just cannot go and swear out an affidavit that I have good reason to believe and do believe that somebody else did something that's against the laws of the state of Texas, and I don't have no knowledge of it. I can't go to the district attorney's office and say, somebody told me that somebody committed a crime of burglary of a building. That person's name is so and so and so, and the district attorney or assistant district attorney is gonna just file charges against that person because that's not direct information. If you see something, say something. But you can't be going downtown and bringing charges against people because somebody told you something. That's hearsay. It doesn't work that way. So this V. Franklin that I was in the custody of what would he know about it? What I did on Tuesday, December 10, 1991. He didn't see anything, so he can't say anything. But this is what Harris County has gotten away with. So let's assume that Miss Edith Creasy did, in fact, bring criminal charges against me under the provisions of Texas Code of Criminal Procedure Article 1501 and Texas Code of Criminal Procedure Article 2.04. I still must be indicted. The grand jury has to find the second time if I'm getting so sleepy I'm not even thinking clearly. Oh boy. Well, I guess I'll end this video. There is no judgment today against me. A judgment is a written declaration of the trial court signed by the trial judge and entered of record in the minutes of the court. That's what a judgment is. A judgment won't come into existence until it first be signed by the trial judge, and by the trial judge filed with the clerk of the court. That is what is called a rendition of judgment. It does not become enforceable until it is entered of record in the minutes, or as you heard me say earlier, from reading, spread upon the record of the clerk in the minutes of the spread upon the record by the clerk in the minutes. When you go and you look, I think I've showed people before a federal court docket sheet, what it looks like, what it appears, how it appears, what it looks like. And from this docket sheet, you'll see a record of what had been filed in the case. When a judgment of conviction is filed, it leaves a record. There's a record. It's noted on the docket that it was filed. And by filing it, it becomes a public record. Now, okay, judgment. What is it? Was I acquitted? Was our judge to be guilty? So you include in the minutes a statement. Here it is. You enter what the decision was. The entry of a judgment is a ministerial act performed by the court clerk, not the judge, which consists in spreading upon the record, the minutes of the court, a statement of the final conclusion reached by the court in the matter. And what this does is furnishes external, and incontestable proof of the judgment given. So it would read, it is hereby adjudged and decreed in the presence of the defendant, and at least in writing it would read, which is judgments in text are not pronounced to a criminal convict in his presence. This is something that is a ministerial administrative act that is done in writing. Judges don't tell prisoners that have been, because a person is adjudged to be guilty when the verdict finding that person guilty is returned and accepted by the trial judge. So if you go on YouTube and you look at a video of Judge Scary Mary, she's called, and at the length of the video, 5 minutes and 23 seconds, you'll hear her say something to this effect. Do you want me to accept the verdict or your plea? And the person said, yes. The court accepts your plea. That's a conviction right there. When it is accepted, if you plead guilty or a judge, you plead not guilty or nolo contender, then if you plead not guilty or nolo contender, then a finding of guilt must be made. If you plead guilty, then all the judge needs to do is accept the plea. If a jury returns in open court with a plea of guilty against you to convict you, all the judge needs to do is accept. It is, at this time, I know you worked hard and blah, blah, blah. I accept the verdict for the court. At this time, the clerk of the court shall enter this verdict in the minutes of the court, and it will recite in the minutes that form that was returned and delivered to the judge, and what he read first, or she read first, we, the jury, find the defendant, Ronald Dwayne Whitfield, guilty of the felony offense of burglary of a building with intent to commit theft as charged in the indictment, unquote. That's the verdict of guilt, not that a jury returned in open court with a verdict of guilty. Guilty of what? Guilty of what? You have the clerks, I'm telling y'all, you must, as the law require, record, recite in the minutes exactly what the verdict is, fully, not abstract. We, the jury, find the defendant. Take the time. It's your job. They paying you to do it because you make these judges and these courts and these prosecutors come back with problems. Prisoners are like me in prison, waiting to catch you hoes slipping. This is not something that's technical. These are the procedures. You have to follow these procedures. Okay. So, I think that's all I want to say today. I'm so tired and sleepy. Can't do the real habeas corpus for my son. And if this video is, the way I performed here is, not good, then hey, I'll do better next time. But I am very sleepy. Good night.